All right, let's dive right in today. We're tackling California's workers' comp system. Specifically, what happens when there's a medical dispute.
It can get pretty complicated, right?
Exactly. Think of it like this. You're on a mission to figure out how disputes are resolved. We've got some great source material for this deep dive, excerpts from Chapter 11, and it all revolves around these medical legal evaluations.
Oh, yeah, those are key.
We're talking QMEs and AMEs. Now, before your eyes glaze over,
I know, right? Lots of acronyms.
think of QMEs, qualified medical evaluators, and AMEs, agreed medical evaluators, as medical detectives. They're not treating the injured worker, they're examining the evidence, like medical records, to give an expert opinion.
It's like a puzzle they have to solve, figuring out what's really going on with the injury.
Exactly. And those evaluations become super important when, say, the employer and the employee don't agree with what the treating physician says.
Yeah, that happens all the time.
So let's say a worker hurts their back on the job. The doctor says, okay, you need 6 weeks of physical therapy. But the employer says, no, 3 weeks is enough.
Boom, dispute. And that's just one scenario.
Right. Or maybe there's a disagreement about whether the injury is even work-related at all, or how much of a disability is because of something that already existed before the injury happened on the job.
Uh-huh.
Lots of potential for disagreements there.
Absolutely. And those are the kinds of disputes that often lead to a medical legal evaluation. It's a way to get an independent opinion to try to settle things.
Okay, that makes sense. Now, I'm seeing this term permanent and stationary pop up a lot in the materials. What does that even mean?
Oh, that's a big one. Permanent and stationary. We call it PNS for short. It's a legal term. Basically, it means the injured worker's condition has stabilized. It's not expected to get any better or worse with more treatment. The treating doctor issues a PNS report summarizing everything.
So even after a doctor says someone is permanent and stationary, there can still be disagreements about the level of disability, maybe.
All the time. And that's where our QMEs and AMEs come back into play. They're the ones who help resolve those disputes. But the way they're chosen is different depending on whether you're talking about a QME or an AME.
Okay, let's break that down. What's the difference between a QME and an AME?
So QMEs, they're appointed by the DWC Medical Unit. That's part of the state's Division of Workers' Compensation. And these QMEs, they've jumped through a lot of hoops, passed exams, met all sorts of requirements to make sure they're qualified.
So they're like the official experts chosen by the state. Got it. What about AMEs?
With AMEs, both the worker and the employer, along with their attorneys, have to agree on a specific doctor, so everyone has to be on board.
Interesting. So in that situation, everyone's saying, we trust this doctor to give a fair opinion. Makes sense. But why not always just go with an AME then? Seems like that would be simpler.
You'd think so, wouldn't you? But there are a few reasons. One, AMEs don't have to be QMEs. They just have to be licensed physicians acceptable to both sides. And here's the kicker. AMEs are only an option if the worker has an attorney.
Ah, so if a worker is representing themselves, they automatically go through the state's QME system. It's like a safety net to make sure they still have access to an independent evaluation.
Hmm.
What about the folks who do have lawyers? How do they decide which route to go?
Well, that's where strategy comes in. It often boils down to whether they think they can agree on an AME they both trust. If not, the QME process is there as a neutral option.
So choosing between a QME and an AME is almost like the first move in a game of chess.
You got it. And knowing how each one works can be a real advantage for both the worker and the employer.
So when would choosing an AME be a good strategy?
Sometimes both sides might have a specific doctor in mind. Someone they know has expertise in the type of injury involved. Or maybe they want someone known for being really thorough. Choosing an AME gives them that control.
Right, so it's about finding an expert who really understands the nuances of the situation. Okay, what about the QME route? When might that be the better choice?
If there's a lot of tension between the two sides, or if they just can't seem to agree on an AME, then the QME process offers that neutrality. It's like saying, okay, let's let the state system give us an unbiased expert.
Makes sense. All right, let's walk through that QME selection process. Let's say we've got a worker with an attorney and they're going the QME route. What happens?
Well, the DWC Medical Unit, they create a list of 3 potential QMEs. And here's the key. It's a randomized list.
So it's not like browsing a directory and picking whoever looks good.
Nope, it's all about keeping things fair. No bias in the selection.
Okay, so we've got our 3 names. What's next?
Now it gets strategic. The worker's side and the employer's side, they each get to strike one name from the list. Whoever's left as the QME will do the evaluation.
Ah, so there's some strategy involved. trying to eliminate the QME they think might be less favorable to their case.
Hmm.
Interesting. But even with all these safeguards, I imagine there can still be disagreements, even after a QME or AME has weighed in.
Oh, absolutely. One of the big ones is this whole concept of apportionment.
That word keeps coming up. What exactly is apportionment, and why is it such a big deal in these cases?
Apportionment is all about figuring out how much of the worker's disability is due to the work injury itself and how much is from, say, an old injury or a pre-existing condition. It's about splitting things up. Like, let's say someone with a history of back problems hurts their back again at work. Apportionment determines what percentage of their current disability is from the new injury and what percentage was already there.
Okay, so it's like dividing a pie based on how much each factor contributed to the disability. But why is it so controversial?
Well, because it directly affects how much the employer has to pay. They're only responsible for the portion of the disability that's directly related to the work injury. So if a disability is 50% from the work injury and 50% from something else, the employer is only on the hook for 50% of the costs.
I see. So it has a huge impact on the financial outcome for everyone involved.
Yeah.
No wonder it's often a source of dispute.
Exactly. And that's just one piece of the workers' comp puzzle. There are so many factors at play.
Well, we're starting to put those pieces together. And it's clear that these QMEs and AMEs play a critical role in the process.
They're essential. But let's not forget, it's not just about resolving disputes over disability ratings. These medical legal evaluations can also be crucial when it comes to figuring out if a worker is ready to go back to work, and if so, what kind of limitations they might have.
Right, that's a whole other layer. And it makes me wonder about the evaluations themselves. So these return to work evaluations, what are QMEs and AMEs looking at when they're trying to figure out if someone's ready to go back to work?
Well, it's all about figuring out what the worker can and can't do, in terms of their job. Like, can they physically handle the tasks?
Right, so it's not just are you healed, it's can you actually do your job?
Exactly. The QME or AME, they'll look at the worker's medical records, of course, do a physical exam, maybe even watch them try to do some of their job tasks to get a better idea.
Okay, I'm with you so far. But what if the QME or AME says, this worker can't go back to their exact same job, even with some adjustments? What happens then?
That's where things can get tricky. California law, it's pretty strong when it comes to protecting workers' rights. Like, employers usually have to provide reasonable accommodations for employees with disabilities, unless it would be a real undue hardship for the business.
I bet that can be a point of disagreement. How do they define reasonable accommodation and undue hardship?
Yeah, those are legal terms, and they're not always crystal clear. They can be up for debate. Reasonable accommodation could mean changing work hours, giving them special equipment to help them do the job, or even changing some of their job duties. Undue hardship is tougher to define, but it usually means the accommodation would cost the employer way too much money or really disrupt their business.
So it's a balancing act. You got to protect workers, but you also have to consider what's realistic for the employer.
You got it. And QMEs and AMEs, they're a big part of finding that balance. Their evaluations help figure out what accommodations are necessary and if they're actually doable.
Makes sense. Now, our source material also mentioned these medical legal evaluations can be needed if new problems come up after an injury. Can you give me an example?
Sure. Imagine a worker hurts their back, and at first everything seems fine, they're recovering, but then, months later, they start feeling numbness in their leg. Uh-oh.
Yeah, that doesn't sound good.
Right. It could mean a nerve problem or something. That changes the whole picture, the treatment, everything.
Okay, so in that case, you need another evaluation to see how serious this new problem is and how to treat it. But wouldn't the regular doctor handle that? Why bring in a QME or AME?
Usually, yeah, the treating physician would handle it. But what if the employer doesn't think this new leg problem is from the original injury? That's when you might need a QME or AME to give an independent opinion.
Ah, so it's back to resolving disputes, making sure the worker gets the right care, even if things change down the line.
That's it. It's about protecting the worker and making sure the workers' comp system works the way it's supposed to. And speaking of things that can cause disputes, our source material also talked about disagreements over the bills for these medical legal evaluations.
Bills. Yeah, those are never fun. What kind of problems come up?
Well, sometimes it's about when the evaluation happens.
Hmm.
The source said it's important to do it at the right time, not too soon after the injury.
Why is that so important? Wouldn't doing it early get things moving faster?
You'd think so, right? But if it's too early, the worker might not be fully recovered, so the evaluation won't be accurate. It's like trying to judge a pie before it's finished baking. You might think it's a disaster, but give it time and it might turn out great.
Oh, I see. Rushing the evaluation could lead to the wrong conclusions and hurt the worker in the long run. Okay, so timing is key. What else do QMEs and AMEs need to watch out for when it comes to these evaluations and their bills?
No unnecessary tests. They shouldn't just order every test imaginable just in case. It's about using their judgment to pick the tests that are really needed to figure out what's going on. Too many tests just cost more money and don't always help the worker.
So they got to be thorough, but also careful about not going overboard. It's like being a detective, got to focus on the right clues.
Exactly. And speaking of being careful, they have to be upfront about how much everything will cost, especially if they need to do any unusual or expensive tests. Nobody likes a surprise medical bill.
Oh yeah, those are the worst. If you're not clear about the costs from the beginning, it can cause all kinds of problems.
For sure. And that's where understanding the workers' comp fee schedule comes in.
Hold on, the fee schedule, what's that?
It's like a price list for medical services in workers' comp cases. It tells you how much each procedure or evaluation should cost. That way, everyone knows what to expect, and it prevents providers from overcharging.
So it keeps things fair and transparent. And both QMEs and AMEs have to follow those set prices. Right.
Absolutely. They have to stick to the fee schedule when they're billing. It helps prevent disputes and keeps the focus on providing good medical care and resolving disagreements fairly.
Okay, so we've talked about timing, avoiding unnecessary tests, being upfront about costs, and following the fee schedule. Anything else QMEs and AMEs should keep in mind to avoid problems with billing?
They got to follow the rules and keep good records. Submit bills on time, give detailed descriptions of what they did, and use the right codes for billing. Basically, be organized and clear.
Sounds like good advice for just about anything in life, really.
Pretty much. But let's be real, even when everyone tries their best, sometimes disagreements about bills happen. So then what?
Yeah, what happens when things go wrong?
Well, first, you try to talk it out. See if you can reach a compromise. But if that doesn't work, the provider can file a lien against the case.
A lien. Oh, that sounds serious. What does that mean exactly?
It's like putting a hold on the worker's benefits. The provider's saying, I'm not letting this case be settled until I get paid for my services.
So it's a way to make sure the provider gets their money, even if there's a dispute. What if that still doesn't work? Is there some kind of judge who decides?
If they can't work it out, it might go to the Workers' Compensation Appeals Board. We call it the WCAB.
The WCAB. I've heard that name before, but I'm not really sure what it is.
Think of it as a special court just for workers' comp cases. They have judges who are experts in this area, and they can make decisions about all kinds of disputes, including those pesky bill disagreements.
So it's like a last resort when all else fails. You go to the WCAB and let them sort it out.
Yep, that's about right. And it just shows you how complex the workers' comp system can be. Lots of twists and turns.
We've definitely uncovered a lot today, from QMEs and AMEs to return-to-work evaluations, billing issues, and even the WCAB. It's a whole system designed to address all sorts of challenges and protect both workers and employers.
It is. And while it can seem overwhelming, there's help out there.
That's true. And remember, we've been focusing on California. Makes me wonder, how do other states handle this stuff? Do they have similar systems, or are they completely different?
Great question. It reminds us that we've just scratched the surface here. Each state has its own way of doing things. It's a whole other world to explore.
A whole other deep dive waiting to happen. And it gets you thinking about the bigger picture, right? Like, how do we balance protecting workers and making sure businesses can function? What's the best way to resolve these medical disputes so that everyone feels like they're treated fairly?
Those are the real questions, aren't they?
For sure. Well, I think we've done a pretty good job of navigating California's workers' comp system today. Hopefully, our listeners are feeling a bit more informed and maybe even empowered.
I hope so, too. The more you understand how the system works, the better off you'll be.
Now, before we go, let's circle back to that question about other states. I encourage everyone to do some research, see how things are done differently in other parts of the country. There's always more to learn.
Keep those brains working. We'll see you next time for another deep dive into a whole new world of knowledge.
It's fascinating, isn't it, how workers' comp is about so much more than just rules and regulations.
Absolutely. It's about people's lives, their health, their ability to work and support themselves. It's a system with a really human side to it.
That's a great point. It's easy to get lost in the legal details, but at the heart of it, it's about helping people get back on their feet after an injury.
Exactly. So, as we wrap up our deep dive into California's workers' comp system, especially those medical legal evaluations, let's recap what we've learned just to tie it all together.
Sounds good. Where should we start?
Well, those QMEs and AMEs, they're the stars of the show, right? They're the ones who help untangle those medical disputes, the disagreements that can pop up between the worker, the employer, and the doctors.
Right. They're like expert translators, helping the workers' comp system make sense of all the medical stuff.
Exactly. And we talked about how they're chosen, how it's different if you're talking about a QME or an AME, and how that choice can be a strategic one.
We also went deep into those return-to-work evaluations, how QMEs and AMEs figure out if someone's actually ready to go back to work, and all the factors they have to consider.
And then there's apportionment, which can be a real sticking point. It's all about separating out how much of the disability is from the work injury and how much might be from other things.
Right. That one's a big deal because it directly affects how much the employer is responsible for. And of course, we couldn't forget about those pesky bills.
Oh, yeah, those medical legal bills can be tricky. But we covered some key tips for QMEs and AMEs to avoid problems, like being clear about costs, not ordering unnecessary tests, and keeping good records. It all comes down to fairness and transparency.
Well said. And for those of you wondering how things work outside of California, remember that question we posed? How do other states handle these medical disputes in workers' comp?
Each state has its own unique system. It's a whole other area to explore, a reminder that there are different approaches out there.
So much to learn. Well, to everyone out there navigating the world of workers' comp, remember, knowledge is power. Understanding the system, knowing your rights, and getting expert help when you need it can make all the difference.
And never forget, it's about people. Real people dealing with real challenges. Keep that human side of it in mind.
That's a perfect thought to end on. So until next time, keep exploring, keep learning, and as always, keep those questions coming.
Thanks for joining us on this deep dive. It's been a pleasure.